For the bankruptcy world, it was a busy week in the U.S. Supreme Court. We had two opinions touching on bankruptcy. Interestingly, the one that seems less important may actually turn out to be much more important. But let's start with the opinion in the case called Rodriguez versus FDIC. That is ostensibly the more important. And that case deals with who owns a tax refund when you have a dispute between a holding company and a subsidiary. In that particular case, the bank holding company was in Chapter 7 with a trustee. The bank subsidiary, naturally, was in an FDIC receivership. There was a $4 million tax refund owing on account of the losses of the bank subsidiary. But the trustee and the FDIC could not agree upon who owned the refund. In some federal circuits, there is a presumption that the entity that generated the losses, in this case the bank, is entitled to the refund. About an equal number of circuits hold otherwise and say that the dispute is resolved under state law. The Supreme Court unanimously decided that the usage of so-called federal common law is going to be very few and far between. The Supreme Court told us that the circuits are going to be allowed to create federal common law only when there is a significant federal interest at stake, and there is none with regard to the ownership of a tax refund. So they remanded the case to the circuit to figure out who gets the refund. The seemingly less significant case was a per curiam decision that is, I think, going to be referred to as the Archdiocese of San Juan, Puerto Rico. In that per curiam, obviously unanimous decision, the Supreme Court said, well, they didn't say, they pretty much banned the ability of federal courts to issue orders nunc pro tunc. With no qualification hardly at all, the Supreme Court said that you can make an order nunc pro tunc only if there was a decision made in the federal court, but because of inadvertence, no order was entered. Now, we all know that in the bankruptcy world, orders are frequently entered nunc pro tunc, but I guarantee you that that cannot and will not be done in the future. The question that folks have in their minds these days is, may a bankruptcy court nonetheless make its order retroactive? Because very frequently we do have retroactive orders, and they are quite important. For instance, retention of counsel. Very often the orders authorizing the retention of counsel will not be entered until some days or a week or two after the filing of a petition, and routinely bankruptcy courts make those orders effective as of the filing date. And likewise, now let's say rejection of executory contracts, the court will make the rejection effective as of the date of the filing of the motion. Now, I must confess, I don't know how the courts are going to come down on this, especially if the issue reaches the U.S. Supreme Court. Although there is a, let's call it, blanket prohibition against making orders nunc pro tunc, may courts nonetheless make their orders retroactive to some time when I guess they already had jurisdiction. Well, that's an issue that's going to work itself out in days to come, but in the meantime, be careful when you draft an order. Don't use nunc pro tunc. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. I will return same time next week, possibly reporting on the last remaining decision so far that has been argued in the bankruptcy realm in the U.S. Supreme Court. That also involves Puerto Rico, but we'll get into that when it comes down. So, goodbye until next week, and I hope wherever you are, it's warmer than where I am. Good day.